Khandeparkar sir has also joined. Khandeparkar, you are there? Hello. Khandeparkar, you are there?
Yes, Agram, I am there. Yes, yes, I am there.
So,
I am very much there.
Okay. So, will you inform sir to join?
Yes, I will.
Okay, please. So, I am waiting.
Yeah. हा सर, तुम्ही येऊ शकतात. हा, कनेक्ट करू शकता. थँक्यू सर. Yes, Agram. Sir will join in a minute.
Yes, sir. Sir has joined.
Yeah.
Good afternoon and welcome all my friends. This is the 18th webinar we have been hosting. Today we have a very eminent jurist who will be delivering a lecture on the subject of culpable homicide amounting to murder, culpable homicide not amounting to murder, and capital punishment. I will ask Mr. Khandeparkar, who is a senior lawyer and a very good friend of mine, to introduce him. But before that, I would like to share a memory, because I still remember when I was just maybe 7 or 8 years of practice, and I had briefed Khandeparkar sir in a criminal appeal, wherein a bail was pending, and that bail came up for hearing before Hon'ble Justice V.M.Kanade sir. And I still remember it was a prestigious matter. When the bail application came up for hearing, the moment he started the hearing of that bail application, the first words were, Mr. Khandeparkar, I will issue a notice of enhancement of punishment in this matter. And I'm telling you, I was really scared at that point of time. It was a very prestigious matter. But Mr. Khandeparkar slowly started arguing. We had a very good point, because the complainant, that is the mother of prosecutrix, had lodged a similar complaint to police of rape against her daughter. And we had brought all that evidence during the trial. So I kept on pushing Mr. Khandeparkar that you pointed out to the Honorable Judge, but he kept on avoiding it. So I was really confused and scared that I thought that bail application will be rejected. 1, 2, 3, 4 points were raised. And at the end of it, Mr. Khandeparkar brought to the notice of Honorable Justice V.M.Kanade the background in which the complaint was filed. And it was a matter of seconds that bail application was allowed. Such a personality he is. From one extreme to other extreme, appreciation of facts and evidence and law. That is the kind of jurist he was, and such a great personality amongst us today to discuss a very important subject. I would request my senior friend Abhay Khandeparkar sir to kindly formally, because everybody knows Kanade sir, but still formally introduce Honorable Justice Kanade, former Judge, Bombay High Court. Over to you, Khandeparkar sir.
Produce such a wonderful personality and a multifaceted personality. Friends, Justice Kanade was born on 22nd of June 1955. Started practicing in the Bombay High Court since June 1979. He appeared in trial courts in civil as well as criminal side before exclusively practicing in the High Court since 1984, where he appeared in the High Court of Bombay in civil and constitutional cases on appellate as well as original side, as well as on criminal side. He also appeared in several educational matters. He also appeared before the CGAT in excise matters. He was appointed as the assistant government leader in the year 1988 and worked as AGP till the year 1990 in the writ cell. And thereafter, in 1986 to 1989, he was a panel counsel in the High Court for
Union of
Union
India.
of India. He was appointed Union of India. And from a panel counsel for State of Maharashtra from 1992 to 2000. Justice Kanade appeared on the appellate and original side of the High Court, Bombay, in writ petitions under Article 226 and 227 of the Constitution of India. He was also a part-time lecturer in New Law College, Mumbai, from 1985 to 1991, and a visiting professor, Department of Law, University of Mumbai, from 1992 to 1995. On 12th of October 2001, he was elevated as High Court judge. As a High Court judge, apart from discharging his functions as a judge, he was also an executive chairman of the Maharashtra State Legal Services Authority, Mumbai, as well as the chairman of Main Mediation Committee of the Bombay High Court. He also worked as director of Maharashtra Judicial Academy. He worked as the chairman of the committee monitoring functioning of the juvenile justice boards in the state of Maharashtra. He worked as a chairman of the governing council of Government Law College. I'm happy to say that he was the acting Chief Justice of the Bombay High Court from 2nd of December 2015 to 9th of December 2015, and from 15th January 2016 to 20th January 2016. As a judge of the Bombay High Court, judgments, out of which 1200 are reported judgments. More than at present, he is an arbitrator and has been appointed as an arbitrator in several matters by the Bombay High Court as well as the Supreme Court, and is on the panel of arbitrators prepared by the Bombay High Court. He's on the panel of IMC International ADR Center. He was appointed as the administrator of the Mumbai Cricket Association from 11th of March 2018 to 15th September 2018. That was the time when the Mumbai Cricket Association would have, but for his able administration, gone through a very bad time. Invited to participate and giving presentations in international seminars held in Bangkok and Phuket in Thailand in 2014 and 15, and has also attended and participated as well as made presentations in the seminar at Singapore, organized on behalf of Commonwealth countries in 2014. He was invited and participated in seminar on commercial litigations held at Hong Kong in 2016 on commercial law and litigations. Dear friends, I must tell you that I have known the Honorable Justice Kanade in his various facets. A friend at the bar, a very dear friend at the bar, then a colleague professor in New Law College, a senior where he led me in a matter for final hearing, that too on the last day, I remember it very distinctly, last day before the commencement of the Diwali vacation before Justice Lodha. then as a judge. I had also the benefit of interacting with him when he was the administrator of the Mumbai Cricket Association. He's been a wonderful person at heart and has conducted his court always with dignity, maintaining the dignity of the lawyers, was always preferred by the lawyers. They enjoyed appearing before him. Such a wonderful personality. And my dear friends, I would not stand between you and Honorable Justice V.M. Kanade. Over to you, sir.
Thank
Justice
you very much
V.M.
for the
Kanade, sir.
kind words expressed by you and Mr. Desai. I don't know whether I am worthy of such kind words which you have said about me. Anyway, let us turn to the topic for discussion today, which is a very vexed problem, which is which has vexed the judges of the Sessions Court and the High Court and the Supreme Court for a very long time. And though most of the senior advocates are quite aware, but it is always beneficial to again brush up the provisions of law. The subject is murder and culpable homicide not amounting to murder, distinction between the two. See, what I propose to do is, first of all, I would like to tell you, I don't propose to give you a lecture. I would like to have a heart-to-heart talk with all of you, share my experiences as a lawyer, as a judge, and try to, in the best possible manner at my disposal, stress the distinction which has been made by law. And for this purpose, I propose, I believe I can't see the face of the participants, but I'll continue.
Sir, we have purposely asked them to mute their voices and switch off their videos so that there is no disturbance.
Okay.
Yes,
Very good.
yes.
So, what I propose to do is this. I would like to discuss the issue in three parts. One is the historical background of the provision about the criminal law. Secondly, provisions in the Indian Penal Code. Thirdly, the precedents, judgments of our High Court, few judgments of the Supreme Court. And then, if time permits, I would like to discuss the provisions regarding death penalty. So let us begin with the historical background. You see, it is an established fact that we have adopted the Anglo-Saxon jurisprudence in respect of criminal law. Most of the key criminal acts were passed by the British Parliament in the 19th century and have continued to remain in force even after the Constitution of India was enacted and brought into force. The Indian Penal Code is as old as 1860, and the Criminal Procedure Code and the Evidence Act are also passed at the same time, near about the same time. Since then, the law has evolved, but we must note one thing, that most of the provisions of the Indian Penal Code have remained unamended, and the same is true about the provisions of Section 299, which defines culpable homicide, and Section 300, which defines murder. So there is a long history behind these provisions, and Lord Macaulay, who was the architect of these acts, had drafted the bill and had presented it in the British Parliament. I must tell you that Lord Macaulay, though he belonged to the British government or he was a British citizen, which ruled India, yet he did not put his faith in the executive of the country, named particularly the police. And therefore, you will find that some distinction has been made by him in the law in respect of manslaughter or murder, uh, homicide and murder in the United Kingdom, and the law which is made applicable to India. So far as manslaughter is concerned, the burden of establishing that there was a homicide, culpable homicide, is on the prosecution in England. However, to bring it to a lesser offense than murder, the accused has to lead evidence or has to establish that his case does not fall under the graver degree of murder. Whereas in India, you will find that the entire burden of establishing that a person has committed murder is put entirely on the prosecution. If you at this stage, I would like to refer to you the provisions of CRPC. You will find that there is a definite philosophy to be found in the various provisions of CRPC. You will notice that though the British Parliament passed the act, it was very well aware that in a developing country like India, it was not possible to put complete faith in the police machinery. And therefore, the CRPC is drafted in such a way that at every stage, the police has to approach the judiciary or the magistrate for the purpose of right from the time an FIR is lodged to the time where a judgment is pronounced by the trial court, high court, or Supreme Court, high court, sessions court, and Supreme Court. So at each and every stage, after a FIR is filed under 154 CRPC, the police has to give a vardi to the magistrate. The reason being that if there is a delay in filing the FIR or giving vardi before the magistrate, the defense can certainly raise doubts about the authenticity of the FIR and can raise a doubt regarding the possibility of fabrication of the FIR at a subsequent stage. Thereafter, for investigation, also the police has to come back to the magistrate or the sessions court, particularly where a period of 90 days is over, though it is not necessary to take permission. There is no provision under section 173(8) to take permission of the court to further investigate. The Supreme Court has said that as a matter of courtesy, the prosecution is duty bound to again approach the magistrate and seek further investigation, even after the period of 90 days is over. So, at various stages, from filing of FIR to filing of the report under section 173, which is known as the charge sheet, and thereafter, during trial, the prosecution has essentially to bring certain facts to the notice of the sessions court or the magistrate. Now, for example, after an accused is arrested, within 24 hours, he is supposed to be brought before the magistrate. All these provisions have been made in order to ensure that the accused gets a fair and transparent trial. You may wonder, sometimes I find people, laymen, saying that why the accused should be pampered in this manner? Why he should be given such latitude? And why all these provisions are made, which are accused-centric? The answer lies in the history of laws of England, criminal law of England, where the criminal law evolved over a period of time, over a period of almost 500 to 600 years. And various safeguards were introduced. Way back in the 12th and 13th century, you may have heard that the only way of trying an accused was to bring him before the ecclesiastical jurisdiction, where the priests used to preside over the trial. And the only way of finding out whether he was guilty or not was to give the accused, give an iron rod which was heated and put it in the hands of the accused. And the result was that if the accused was burned, his hands were burned and scalded, he would be pronounced as guilty, because had he not, God would have saved him. So such were the drastic laws in England. You will be surprised to know that as far back as the 20th century, in the early 19th century, there were almost several petty offenses for which the only penalty, if proved, was death. So the law evolved, and necessity of cross-examination, statement of the accused under 313, and the opportunity to the accused to give explanation were introduced. So of course, now in the late 20th century and early 21st century, we find that several provisions have also been made to ensure that the victim also gets the right. Particularly the latest amendment, where I think 2012 or 13, where the accused also, the victim also has a right to file an appeal if the prosecution does not file an appeal under section 372. So you will find that even section 300, even before the constitution was enacted in 47, 48, 49, the principle of double jeopardy was introduced in Article 20. But you will be surprised to know that in CRPC, the provision was already made by the British Parliament. And we find section 300 specifically says that if the accused is tried once for the same offense, he cannot be tried again at a subsequent stage. So many of the safeguards which we find in the Constitution were already there in the CRPC. So having just taken a cursory view at the provisions of the CRPC, let us go to the Indian provisions of the Indian Penal Code. The Indian Penal Code is a very comprehensive act where classification has been made of the offences and in a particular manner. And we find that there are several chapters introduced in it which take into consideration various aspects of administration of criminal law. Since we are concerned only with the provisions of section 299 and 300, we will concentrate on the ingredients of the offense of murder and the distinction between culpable homicide not amounting to murder. Before I go to the actual provisions, it will be necessary to also consider the chapter on general exceptions. There is one chapter which particularly deals with general exceptions, which takes away the liability of the accused if he commits this act under certain exceptions. For example, right of private defense. Then the right of a public servant if he does any act in the discharge of his duties, public duties. Then there is a provision regarding insanity, section 84 if I am not mistaken, where 284 or 84, I don't remember now, but 84 clearly says that if a person is not in a position to arrive at a judgment or understand the consequences of his action, at various stages, he can plead the plea of insanity. So, having just considered these provisions, let us now go to the main section. Section 299. Section 299 defines what is culpable homicide. Now, one thing you have to note here that sometimes we wonder why this particular method, a circuitous method of defining culpable homicide, which is the genus, has been made, and then the statute proceeds to define murder and carve out exceptions to murder. The reason possibly is, I believe, that it was necessary to first define what is culpable homicide. Because in order to establish, before establishing whether a person has committed murder or not, it has to be established that the person has committed homicide. So the person who is responsible, culpable means responsible. Person who has committed is responsible for committing homicide has to be first determined. So in a criminal trial where the offense is charged under section 300 and punishable under 302, it is first necessary for the prosecution to establish that there was a homicide. Then the second stage is to decide whether this culpable homicide amounts to murder or does not amount to murder. And I believe that that is the reason why this circuitous method has been adopted. I believe that whenever we consider the provisions of any act, it is necessary to first see the section first and then make a comment on it. I remember I was appearing as a very junior lawyer in 1984 for one of the former chief ministers of Maharashtra, Shri A.R. Anthule. And there were several senior lawyers, Ramakant Olekar, Gadge, Shamrao Samant, and several other dignitaries were there. Several important issues were thrashed out in that matter, which went on in the High Court. The trial was conducted in the High Court, and it went on for 4 or 5 years on a daily basis. And thereafter, again, it went to the Sessions Court. So in the initial stages, several issues like whether sanction is necessary to prosecute a public servant, whether MLA is a public servant, whether a chief minister is a public servant, were discussed and decided. I remember the issue was whether sanction is necessary under 197 and section 6 of the old criminal act, criminal corruption act. And we had invited, we had called an eminent criminal jurist, criminal lawyer, Shri Rajendra Singh from Jabalpur. So we had a conference. He was staying in Natraj Hotel. Now it is the Intercontinental Hotel. And we went there with our books and proceedings. It was a private complaint. And the complaint and other documents filed along with the complaint. We went there, and after having a cup of tea, we started a discussion. Rajendra Singh said, let us first see provisions of section 420. And then he went on to read the provisions of various other provisions for which you are likely to be charged. Then we went to the criminal complaint documents, etc. The conference lasted for about 2 hours, 2-3 hours. And after the conference was over, we had tea. By that time, Rajendra Singh had put in 55 years of practice in the High Court and Supreme Court. So I asked him that, sir, can I ask a question? He said, yes, son, please go ahead. So I said that, sir, by this time you must be knowing the provision by heart. You have put in so many years. Why was it necessary to read the section again? So he said, look, son, you have asked a very important question. Since you are a junior lawyer, I must tell you. He said that you must develop a practice of referring to the section whenever any new case comes to you. Because the section has various hues and can be applied under different circumstances. So whenever any new case comes to you, with reference to the facts and circumstances of the case, when you read the provision can throw some light and you can find out what defense you can carve out and make your submission accordingly before the court. And he said that if you follow this practice of referring to the main section, you will be successful at the bar. So, therefore, friends, I am quite aware that most of you are trial court lawyers and have practiced, have conducted sessions trials, and you are very much observant. But it is always better to see the provisions. I would request Mr. Abhay Khande Parkar, Senior Advocate, and Sangram Desai to ask the participants to share these provisions so that I can brief succinctly uh,
Sir, I have
discuss.
circulated the provisions. They are there already.
Okay, so I can refer.
Yes,
I
yes.
have my own iPad, so I don't need that.
Yes, sir.
So section 299 is to be found in the chapter of offenses affecting the human body. So this is the most serious offense, and the chapter begins with the most serious offense affecting the human body, namely death. Section 299 defines culpable homicide. Now you will find that there are three parts to the section. One is regarding the cause of death by a person doing an act with the intention of causing death. Now here you must notice that the word act also includes omission. So it is not necessary that person has to commit an act. An omission to do a thing which he is required to do also can be made punishable. I remember I was at the Nagpur bench for about 1.5 years after I was appointed. And I had a case before me where a couple had a child, had a 8-year-old daughter, and they were uh, going to a Baba and taking his advice. So this Baba told them that this child is evil and she doesn't deserve to live. So he advised them not to give her food and water. So they kept her in a room, and after a couple of days, that girl died. When this fact was brought to the notice of the police, the Baba was arrested, and so was the couple. Trial court passed an order. I don't exactly recollect what order was passed, but then the matter came to the High Court before me, before a division bench where I was a member. And the High Court, the division bench of which I was a member, we held that they were guilty of the offense, and the Baba was guilty of abetting the offense. So they were convicted because by the act of omission to give food and water, they were responsible for the death of that girl. So act includes omission. So the first part is quite clear that the intention is of causing death by an act. Second part is or with the intention of causing such bodily injury as is likely to cause death. So second part is also in respect of the intention of causing bodily injury. So the first is a grievous part, there can't be any manner of doubt. The intention is to kill. Second part is the intention is to cause such bodily injury which is likely to cause death. Or thirdly, the third part is knowledge that because of such act, because of such, he likely by such act to cause death. So these three ingredients are to be found in section 299. And one has to remember that essentially there are two aspects. One is intention to cause death, and second is intention to cause bodily injury, and the knowledge to cause such knowledge that such injury is likely to cause. Now, you will find when we read section 300 that there is another provision which says after subclause 2, secondly in 300, subclause 3 says that the offender knows that the injury is sufficient in the ordinary course of nature to cause death. Now, very often we wonder what is the distinction between the two, namely likely to cause death, injury which is likely to cause death, and injury which is sufficient in the ordinary course of nature to cause death. And why such a distinction has been made? Some light can be, we will discuss this when we read section 300 also in detail. But I feel that for that purpose, there are three explanations given below section 299. Now, explanation 1 to 299 says that a person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity, and thereby accelerates the death of that other shall be deemed to have caused his death. So, if a person has a knowledge, take for example, a boxer like Mike Tyson or a karate expert like Bruce Lee, who is an expert in karate, and Tyson is an expert in boxing, champion in boxing. He gives a blow, a single blow, to a child who is, say, 12 years old. Now, such a person would know that if I give even a single blow to a child, he is likely to die. And therefore, when we read 300, you will find that secondly says that even such an injury which is caused, even if it is likely to cause death, it is made punishable under 300 as murder. So explanations somehow throw light on a provision. Explanation 2 further says that where death is caused by bodily injury and the person who causes such bodily injury shall be deemed to have caused his death, although by resorting to proper remedies and skillful treatment, the death may have been prevented. So you can't take a defense that, well, it was a single blow and he was lying on the road, nobody took him to the hospital. Had he been taken to the hospital, he would have survived. Or that the blow was on the leg or some other non-vital part of the body. In the stab wound was on the non-vital part of the body, and If he had been taken to the hospital at the right time, there would have been no loss of blood and his life would have been saved. And therefore, in such cases, he cannot plead that he is not liable. And third is regarding the causing of a death of a child in the mother's. The Indian law is unless some part is protruding out of the mother's womb, the child is not supposed to be a living being. And therefore, if the child is inside, then the death of the child and no part is protruding outside the womb, it cannot be held to be, it cannot be said that he has committed murder. So section 299 comprehensively discusses various acts and makes a distinction between knowledge and intention. Now let us go to section 300. Section 300, which speaks about murder, which defines murder rather, starts in a way where it says, I'll read that section, except in the cases hereinafter accepted. Culpable homicide is murder if the act by which death is caused is done with the intention of causing death. Or secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of a person to whom the harm is caused. Or thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Or fourthly, if the person committing the act knows that it is so eminently dangerous that it must, in all probability, cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. So section 300 in fact itself makes a distinction between what is murder and which is enunciated in the first four parts, namely firstly to fourthly, and then makes an exception that even if any of the provisions are made out under firstly to fourthly, still because of the exception which are mentioned below the section, namely exceptions 1 to 5, the liability is reduced. As you are aware that once it is proved that a person has committed murder, the judge has no option but to either sentence him to life or give him the death penalty. But if the defense is in a position to establish that it is not an offense of murder and that it falls under any of those five exceptions, then sentence can be imposed under the provisions of section 304, which is divided in part 1 and part 2. So there are no specific parts, but for convenience, it is always referred to as part 1 and part 2. So before we go to the exceptions, so the basic distinction you will find between murder and culpable homicide not amounting to murder is to be found in section 300 itself. And if the case falls under one of the exceptions to section 300, then the offense of murder is not made out. And a lesser offense, lesser degree of offense is made out, and accordingly, the accused is sentenced to undergo imprisonment as per the provisions of section 304. Now, let us analyze these four sections very briefly. Now, so far as the first part is concerned, firstly, you will find that there can't be any dispute or It is not necessary to give any detailed explanation. Firstly says first that the provocation is not sought. Sorry. Firstly says that the death is caused is done with the intention of causing death. Now, I remember there was a matter in the civil court, and there was a dispute between a brother and sister. They are all belong to a family of South Indian who owned South Indian restaurants, chain of South Indian restaurants. The father died, and there was a dispute over property between the brother and sister. The sister was adamant she was claiming a share. One day, when the sister had gone to her brother's place, there was there were abuses were heard by both of them, and the brother suddenly took out a revolver, a pistol, and fired 5 shots on her. Though she was injured and received 5 injuries, she survived. She was given immediate treatment, and she survived. And therefore, the charge was under Section 307. And this judge, who basically was a civil lawyer all his life and had become a sessions judge, city civil court judge, and was assigned criminal matters, took a view that this did not amount to an attempt to commit murder because she had survived. And then it was a case of grievous hurt. Of course, an inquiry was made against the judge and he was transferred elsewhere. And the reason is quite simple. With 5 bullet firearm injuries, the intention is very clear. The intention was not to cause bodily injury, but the intention was to cause death. Though it may have happened in the spur of the moment, the intention was quite clear. And the lady who was present in the court asked the judge when the intention would be clear after. If I had died, was it necessary for me to die to prove intention? So very often, therefore, the Judicial Academy was established in the year 2008. Earlier, all the new judges were trained at Jyoti at Nagpur, where they were given 2 months training. And after 2 months training, they were sent to uh, decide cases. So obviously, 2 months training was not sufficient. And the Chief Justice Swatandra Kumar was a person who ensured that within 1 year, the academy is established. There was another case, incidentally, a little digression. Another case where a magistrate, I think in Julia, was a civil lawyer initially. He was given a criminal assignment, was taking bail and other matters. And the case before him was uh, the victim was the owner of a well. And the accused went there, and there was an altercation between the accused and the owner of the victim. So the victim slapped him, and then the accused also slapped him. Now, an application for remand was made. Basically, it was a bailable offense. Though it was a bailable offense, he passed an order, bail granted, but for the purpose of deciding surety, he kept it after 5 days. So the complainant, he had to remain inside for 5 days. So the complainant's wife then made a complaint to the Chief Justice that how this could be done. If it is a bailable offense, even if it is above 5,000 of bail, the magistrate has to immediately grant bail. So therefore, I believe that it is necessary for judicial officers also to be trained, because I believe that gone are the days where you could say that well, criminal law is only confined to three acts: the Indian Penal Code, the CRPC, and Evidence Act. Now it has become a specialized field, and you require some training, some grounding with your senior and in the court. And we, all of us, we learn in the court. I remember, I must mention a little digression, but I must mention here that when I was a junior lawyer, a very junior lawyer who had put in 3-4 days of practice, I was told by my senior to go and mention three matters. The bench was presided over by Justice Tandurkar, very eminent judge of the Bombay High Court, who became the Chief Justice and was then Chief Justice of the Madras High Court. And in our days, all the judges were hard taskmasters. They would hammer the junior and hone his skills through trial and through by using harsh words. So when I mentioned, normally, in 1979, in those days, there were hardly 10, 15 matters, admission matters, urgent or admission matters. And as a matter of rule, practice, all applications for urgent circulation were granted. So I mentioned three matters. So may I, with my Lord's kind permission, mention three urgent matters for circulation. I was not carrying any papers except the precipice. The judge understood that this young man has come to the court without his papers and without reading the brief. So he said, "What is the urgency?" And I was stumped and bold. I had not prepared. Did not know that such a question would come from the court. And then I said, I don't know. My senior did not tell me. So the judge then took me left and right and center, and he hammered me. And he said that, look, you must remember that as a junior lawyer, you must first of all read your papers, even if it is for circulation. You must know your facts. You must know the law. If not the law, at least the facts you must know. And you should never come in the court without preparing yourself, without a brief. And of course, I took it in the right context. I was not offended. And he said that hereafter, when you come to my court, you have to be fully prepared and with a brief. Otherwise, I will throw you out of my court. And then he said, look, Mr. This thing, lawyer, advocate, you must remember you are not your senior's postman. He said, use such harsh words. You are not your senior's postman to bring all these precipices and just throw them before the court. You have to be ready with the matter. And even if the senior doesn't tell you, you should ask him to give the briefs. So that was a great lesson. And thereafter, even if for the application for bringing heirs on the record, I took the civil application to the court and was fully prepared. I am trying to tell you this to the junior lawyers because nowadays I find that the tendency is to take everything for granted. And judges are also not taking much effort, particularly in the trial courts, because it is necessary to prepare the junior bar because they are lawyers of the future. Anyway, let us not go. Let us come back to the main topic. And I was discussing about Section 300. Section 300, firstly, um, I said that first part is very clear, is the intention. Now, we come to the second part. Secondly, is secondly, just right. secondly reads like this: the intention of causing death. Now, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death. As I have told you while discussing 299 explanation, in my view, a very subtle distinction has been made between the word likely to cause death and sufficient in the ordinary course of nature to cause death. The person who intends to cause any injury, if he knows that his act is such that death is likely to be caused, then he cannot be excused. And therefore, even such categories of cases where there is a possibility of a death being caused because of the injury are included in the definition of section 300, murder. Now, let us go to the definition of thirdly. Thirdly reads like this: if it is done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. So therefore, it is in two parts. The first part is an objective part, namely, if it is done with the intention of causing bodily injury to any person. So if it is established by the prosecution that the intention was to cause bodily injury, once that is done, the second part comes into play, namely that the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. So for the second part, the prosecution has to prove by examining a doctor and seek his opinion, who may give his opinion that this injury is sufficient in the ordinary course of nature to cause death. Now this dilemma is found in cases where there is a single injury, namely where there is a single stab wound, and it is not sure whether the intention to cause that injury sufficient or not. Now, in view of the judgments of the Supreme Court, this thirdly has been examined in detail. Firstly, in Virsha Singh's case, reported in 1958 Supreme Court, and secondly, in Punayya's case, reported in 1977, AR 1977 Supreme Court, page 45. First judgment was delivered by eminent judge, uh, and the second judgment has been delivered. First judgment is delivered by Vivian Bose, and the second judgment is delivered by Sarkaria, both eminent judges, and these are classic judgments which even today are referred. So for thirdly, therefore, it has to be seen. Now very often, the word injury is considered as a single injury. It is not necessary. It can be the cumulative effect of all injuries. And if the cumulative effect of all injuries is that the person dies as a result of these multiple injuries, even then it will fall under the clause 3 of section 300. Very often there is an impression that if injury is caused not to the vital parts, then the provisions of section 300 are not attracted, and the case would fall under 304 part 1 or part 2. But then I believe that that is not a correct interpretation of the law. Because take a case, the second case which I am going to refer to is that Punayya's case. Take a case where 6-7 people assault a person with a lathi on his non-vital parts. And the assault is so grievous that all his bones are broken. And the splinters of the bones cut the arteries. And because of excessive bleeding, the person dies. Now, one might argue that the injury is not to the vital part. It is not on the heart or some other vital organ, skull, and therefore the case would fall under 304. But I believe that that is not a correct interpretation. The Supreme Court, in a similar case, has held that it would fall squarely under section 300 thirdly. Now, coming back to the distinction between likely to cause death and sufficient in the ordinary course of nature to cause death. I remember having seen this movie Three Idiots. In that case, there is a scene where the accused is being the hero is being ragged. Amir Khan is ragged, and he goes to his room, and the senior tells him that I will urinate on you. So he takes out a spoon which is connected to an electric wire. And when the senior urinates, it falls on the spoon and he gets an electric shock to his private part. Now, it's okay in the movies, they show anything. But if a incident like this had happened, there is a possibility that because of this shock, the person, there is a likelihood that such person can die because he receives a shock to the private parts. And if unfortunately the person dies, then the question before the court would be whether he is likely to cause death, whether the person who committed this act, whether he should have known that such an act is likely to cause death. Or take a case where poison is administered just out of a prank. Now, poison can act on various persons in various ways. And if a poison is administered, there is a likelihood that the person may die. And if that person dies, then the question is whether it would fall under secondly. So there are several cases where there is a possibility or likelihood because of that act to cause a death of an individual. And if that happens, then it will fall under secondly, and it could be a case of murder. Now, thirdly, sufficient in the ordinary course, the phrase sufficient in the ordinary course of nature is a case where he may not have intended to cause death. His case may not fall under clause 1. But he gives injuries, inflicts injuries of such nature that those injuries are sufficient in the ordinary course of nature. Take a case where accused has an axe in his hand and inflicts with great force one single blow on the skull, and the skull is broken and the brain is damaged and the victim dies. Now, though it is a single blow and the intention has been established that he intended not to inflict blow on the leg but on the head, then in that case it would squarely fall under clause 3. There's a case decided by Justice Swatendra Kumar when he was in the Supreme Court, wherein one of the children, one of the boys, one of the sons of the accused, the father of the accused, was abused by the other son after having consumed liquor. And he had taken out his axe to come and assault him. At that time, the father called his younger son, who came out with a axe, small axe, and inflicted one single blow on the skull of the brother, and the brother died. The Supreme Court held that this would clearly amount to causing an injury which is sufficient in the ordinary course of nature to cause death. So therefore, the intention, one, to cause death, and secondly, intention to cause bodily injury has been distinguished in the four clauses of section 300, and more particularly, the intention and knowledge about the injury which is caused. There are several judgments of the Supreme Court on this, but I would like to refer to two judgments before I go to the exceptions under section 300. The first judgment is in the case of Virsha Singh versus State of Punjab, reported in AIR 1958, Supreme Court 465. And this was a case where several accused assaulted the deceased. The main accused, who was convicted under section 302, inflicted a spear, a blow with a spear on the abdomen of the deceased. And there was one punctured wound transverse in direction to the left side of the abdominal wall. And 3 coils of intestines were coming out of the wound. The man died on the next day. The Sessions Court convicted him under section 302. The High Court also confirmed the sentence, but the High Court referred the question to the Supreme Court as to whether this was a case which would fall under thirdly or under 304 part 1 or 2. The Supreme Court Justice V.M. Bose, and I would, if you have not read the entire judgment, I would request all of you, since now we have a lot of time at our disposal and we don't know when this COVID threat will go, to read the judgment. It's a short judgment. Earlier judgments used to be very short. And I will not read the whole judgment. I'll just point out what the Supreme Court has said as to how you have to prove that the facts bring a case under section 300 thirdly. Supreme Court has said, first, it must establish, prosecution must establish quite objectively that a bodily injury is present. Secondly, the nature of the injury must be proved. These are purely objective investigations. Then it says, thirdly, it must be proved that there was an intention to inflict that particular bodily injury. That is to say, that it was not accidental or unintentional, or that some other kind of injury was intended. Once these 3 elements are proved to be present, the inquiry proceeds further. Fourthly, it must be proved that the injury of the type just described, made up of the 3 elements set out above, is sufficient to cause death in the ordinary course of nature. This part of the inquiry is purely objective and inferential and has nothing to do with the intention of the offender. Once these 4 elements are established by the prosecution, the offense is murder under section 330. And the Supreme Court confirmed the order of the High Court and Supreme Court of conviction of the accused under section 330. So therefore, it's a very beautiful classic judgment. Justice V.M. Bose has delivered several judgments, and this is one of his very classic judgments, where he has analyzed in detail the provisions of the Act and has made a distinction between thirdly and how the case would fall under thirdly and not under 304 Part 1. The second case is the case of state of Andhra Pradesh versus Raya Varapu Punaya and another. Now, this was a case where there were two groups in the village. And these two groups fought elections against one another. And one group had a particular animosity against the deceased. So one day, when they came to know that the deceased was going to go to a particular place. So in the morning when he took a bus, they also climbed the bus. And the deceased got down at a particular place. They also got down. And thereafter, they took out sticks from the uh, agricultural land which was there nearby and assaulted him with those sticks mercilessly, as a result of which the victim died after he suffered multiple fractures. No blow was given on the skull. All the blows were given on the hand and feet, thighs and lower and knees and other parts of the body, but not on the vital organs. Now, the question before the Supreme Court was whether what was argued was that there are no injuries to the vital parts, number one. There are no injuries which could have caused death individually. For example, a blow on the thigh would not have caused death. Supreme Court said no. You have to take the cumulative effect of all injuries, number one. You have to see that the intention was to inflict those injuries. And though the deceased was pleading that please stop, and even others also told those people not to assault him, they continued with their assault till the deceased became unconscious. So the Supreme Court said that the intention was to cause such bodily injury, and that it was sufficient in the ordinary course of nature to cause death. And the Supreme Court has made a distinction between 299 and 300, and has quoted 299 and 300 in a chart, and has distinguished the two sections as to how they differ from one another at crucial places. Now, fourthly, of course, is very clear. It says that where the act of the accused is so eminently dangerous that in all probability it is likely to cause death. So this, I believe, are the four parts of murder. Now let us very quickly go to the exceptions under section 300. There are 5 exceptions. 5 exceptions. And the first exception is regarding grave and sudden provocation. Now, to this exception, it says that it is not murder if the offender, while deprived of the power of self-control by grave and sudden provocation, causes death of a person who gave the provocation, or causes the death of any other person by mistake or accident. Now, this section has 3 provisos. And the first proviso says that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. The second proviso is that the provocation is not given by anything done in obedience to the law or by a public servant in lawful exercise of the powers of such public servant. Thirdly, that the provocation is not given by anything done in the lawful exercise of the right of private defense. So the exception is that if there is a grave and sudden provocation, and because of that provocation, while being deprived of the power of self-control, he commits that act. If it is established, then it would not fall under murder. But in order to ensure that this section is not misused, this exception is not misused, the legislature has ensured various provisos. So it should not be that the accused voluntarily provokes, is voluntarily provoked by the offender as an excuse for killing. And if that is established by the prosecution, then the case will not fall under this particular proviso. Secondly, there are a number of cases which have been reported where a public servant who serves, for example, a bailiff who serves a warrant or summons on the accused, and the accused being annoyed assaults him and commits his murder, then that can't be an excuse, and the said exception will not therefore be attractive. And thirdly, if a person does something in lawful exercise of right of private defense, then also his case will not fall under the exception. There is an explanation which says whether the provocation was grave and sudden enough to prevent the offense from mounting to murder is a question of fact. So these questions are not questions of law, but questions of fact, which have to be established by leading evidence, and the burden is on the prosecution. So this is the first exception, namely grave and sudden provocation. The famous case is that of Nanavati, reported in 1962 Supreme Court. This was a case where a naval officer came to know that the deceased had an affair with his wife. He came to know about this fact on the earlier day, and on the next day he went to the house of the deceased, took out his revolver, service revolver, and fired shots, as a result of which he died. The defense was grave and sudden provocation. Right up to the Supreme Court, this defense was not accepted, and with the result, he was sentenced to undergo life imprisonment. A little digression here, I must point out that though he was sentenced to undergo life imprisonment, the executive, while exercising its power to release a person under Section 432, released the accused after 5 years. This led to a furore, and the power to grant pardon by the executive or to reduce the sentence was discussed, and which resulted in introducing the provision Section 433A. 433A says that notwithstanding what is mentioned in Section 432, in a case where the accused has been convicted for the offense punishable under Section 302 of murder, then he cannot be released unless he has served at least 14 years of imprisonment. Of course, there is also subsequent development, which I do not want to discuss right now, because I think we don't have that much time. So then we go to the second exception, that is regarding right of private defense. Now, as I've already told you, right of private defense of a person and property is an excusable homicide under the general exception. And if it is established that he has exercised his right in the private defense, then he cannot be convicted, and there is no liability. However, by way of abundant caution, it appears that in order to ensure that this exception, general exception, is not misused, it is put under exceptions. And therefore, it says that if he exceeds, the person exceeds the power given to him by law and causes the death of that person, such right without premeditation, then it would not be murder, but it would still be offense punishable under section 304, and it would be a case of culpable homicide not amounting to murder. And the third exception is again a public servant or person aiding a public servant exceeds the power given to him by law. Then in that case also, though he is exempted, or his case can fall under the general exceptions, if it is shown that if he exceeds that power, it would amount to culpable homicide not amounting to murder. And lastly, the fifth exception is regarding a person who is above the age of 18 and gives his consent, say, for a boxing match, participate in a boxing match or a karate competition. And in that process, because of a blow given by the opponent, he dies, then it would not be an offense of murder, but it would fall under the exception 5. So these, friends, are the provisions of section 299 and 300. And I have already referred to the two judgments, Vishya Singh and Punaya. I believe that we don't have time to discuss the provisions of death penalty because I don't think it will be over in a short time. I would like to ask Mr. Sangram Singh, how much time do I have?
Sir, another 15-20 minutes we definitely have. We were going to take a couple of questions also.
Okay.
Hardly 4 or 5 questions also. So
I can briefly discuss about death penalty.
Yes, sir.
Very briefly, 10 minutes, I'll just summarize.
Yes. Not a problem.
As I told you earlier, death penalty was the rule if it was established that a person has committed murder. In England, in the 20th century, the first half of the 20th century, almost there were 200 offenses for which penalty was death. Even for petty offense of stealing a shilling, the offense was death. But thereafter, all over the world, there was a discussion about the efficacy of death penalty. Firstly, on the ground that it is irreversible. And if later on some evidence is brought to light, then you can't bring the person back who has already been hanged. And therefore, in 129 countries, death penalty has been abolished. Now, in India, of course, it has not been abolished so far. But there are two lobbies, one who are in favor of abolition and the other who are not in favor of abolition. The famous judgment on this point is delivered by the full bench of the Supreme Court in Bachan Singh, AIR 1980 Supreme Court. And the validity of the punishment of death by hanging has been upheld. Very often, whenever death penalty is awarded, we find that there is a furore and people then say that eminent jurists then give their opinion that death penalty, why penalty of death should be given. One has to remember that as long as a statutory provision is there, the judge before whom the case is heard, the sessions judge or the confirming high court judge, has no option but to follow the provision of law. So either it has to be death or imprisonment for life. If you see the provisions of CRPC under section 367 subclause 2, initially the wording was that if a person is found to be guilty for the offense of committing murder, then the judge shall give death penalty, and if he wants to give imprisonment for life, he has to give reasons why he wants to commute the death penalty to life imprisonment. Later on, of course, in 1955-56, section 354, subclause 3 was amended. And the amended clause said that life imprisonment shall be a rule. And if the judge wants to give death penalty, he has to give special reasons. And therefore, thereafter, there was a difference of opinion. The question was whether the parliament had said that first life imprisonment should be given, or if the court feels, death should be given. Bombay High Court delivered a judgment that the old law was changed, and now death penalty is an exception. Whereas the Madras High Court held that no, if a person is found to commit murder, even after the amendment, death penalty has to be given first, or special reasons have to be given. The matter went to the Supreme Court because of these two conflicting views. And the Supreme Court reiterated that the intention of the legislature was to ensure that first life imprisonment is the rule. And if death penalty is to be awarded, then it has to be shown that this is a case falling under the rarest of rare cases, and special reasons have to be given. The Supreme Court has considered in Bachan Singh all those aspects, the incriminating circumstances, mitigating circumstances, aggravating circumstances, and has given a formula, which of course in later judgments also the Supreme Court has further elaborated. So in India, as of today, in my view, one cannot argue that in a case where offense of murder is committed, death penalty should not be given because the judge has no option. We in India have to follow the rule of law. And the rule of law says that whatever the provision is there, and irrespective of the personal opinion of the judge, the court has to follow the precedent law and has to find out whether the case falls under the case where death penalty should be awarded or should not be awarded. I remember, and it's a very onerous responsibility. I remember, very briefly, I'll tell you. I remember that my first case, confirmation case, I decided, and I had just put in 3-4 years. I was sitting with Justice D.G. Deshpande, who was presiding over the bench. And this was a case where a driver was working in the house of a couple, was removed. And out of vengeance, he kidnapped their son, 8-year-old son, and first murdered him by strangulation and then demanded 25 lakhs ransom. While collecting the ransom, he was caught red-handed. Circumstantial evidence, DNA evidence, and all other evidence conclusively proved, though it was a case of circumstantial evidence, all those chain of circumstances conclusively proved that this was a case of murder and committed in the most heinous manner. And I was told by the senior judge to deliver the judgment. Of course, we had discussed and we had said that this is a fit case for awarding death penalty. I must tell you, for 2-3 days, I could not sleep. And because ultimately we are dealing with the life of an individual, and a single mistake by by the judge. Of course, Supreme Court is there, but confirming court carries a great weight before the Supreme Court. And finally, after 2-3 sleepless nights, we confirmed the penalty, though the Supreme Court reduced the sentence from death to life. There was one other judgment in which death penalty was awarded by me, where I was a senior judge. That was a BPO murder case. She was working in a call office far away from her house, and a taxi used to come to collect her. On that particular day, the friend of the driver was also there, and they took her to a secluded spot, raped her, and then murdered her. Here also, there were different questions involved, and finally, death penalty was awarded to them. Supreme Court confirmed the judgment, but later on, because death penalty was not immediately executed, there was a delay of a couple of years. The Bombay High Court then reduced the death penalty and convicted them for life. So various cases have to be dealt, and though for want of time, I cannot go into several aspects of death penalty and what are the mitigating circumstances and aggravating circumstances. There is one reference in Bachan Singh's judgment as to whether the court has to decide whether he can be reformed. I believe that this is a very difficult question, because take for example the Nirbhaya case, and in that case, is it possible to decide, having committed such a heinous act, whether he can be reformed or not? What are the parameters? Because we don't have any material. This question aspect has been borrowed from the US courts, and they have the elaborate machinery of probation officers and other officers who keep a track and give a report. So, friends, thank you very much for giving me a patient hearing, and I would like to hear your queries, and I'll answer them to the best of my ability. Thank you.
Yes, sir. Thank you very much, sir. As we are running short of time, I'll directly come to the question and answer session.
Yes.
So the first question is from Advocate Kaustubh Marathi. His question is, sir, can the alternative defenses of total denial and private defense be taken in case of offense under section 302?
I believe that there is no bar, if I am not mistaken, there is no bar to take alternative defense. There is no bar either under the provisions of Indian Penal Code or any other law where alternative defenses are barred. But I am not sure whether the Supreme Court has given any express opinion as to whether such alternative defenses. Normally, the rule is, for example, in civil cases also, if the alternative defenses are diametrically opposite to each other, then such defenses are not allowed. But in this case, I don't think that, because here in the criminal trial, the burden of establishing the case is squarely on the prosecution. And by way of suggestions in cross-examination, the defense, or maybe 313 also, I don't see any reason why an alternative defense cannot be taken.
Cannot be taken.
If it cannot be taken, let me know. Please tell me if there is any judgment. Ask Mr.
No,
Marathi.
sir. Yes, Mr. Marathi has he has asked this question, but we have muted all this, therefore he won't be able to reply, sir, unless he messages me. Okay. So the next question is from Advocate Umesh Sawant, and his question is the recovery of dead body, the corpus delicti, necessary, essential for conviction of a murder case?
Right. So you see, in a murder case, normally, as I told you, that the first duty of the prosecution is to establish that there is a homicide, and to establish that you have to show that the person has died. Unless you produce the corpse, how can you proceed to the next question? But later on, I believe the Supreme Court has said that in a given case, if there is unimpeachable evidence to show that the person has died an unnatural death, and that all the evidence shows that the accused has committed that act, then in rare cases, corpus delicti, that is the corpse, even if it is not detected, a person can be convicted. This is
Yes,
my view.
yes, sir.
Right.
So the next question is, under section 354, subsection 3 of CRPC, life imprisonment is a rule and capital punishment is an exception. What
Right.
are those special considerations to award extreme penalty? I mean, you have referred to it, but this is a question.
Yeah. You see, as I told you, Supreme Court in various judgments from 1980 onwards, and even before that, has given a list of, has prepared a formula to find out what are the mitigating circumstances, what are the aggravating circumstances, and if the case falls under aggravated circumstances. Now, I cannot offhand state what are the aggravating circumstances, but normally the rule is that if the act is so patently heinous and shocks the conscience of the court and the people, then in such case that would be a strong ground. I had one case before me of Pune, where a street driver had moved down about 38 people. He was
Yes.
driving the ST bus for about 2 hours throughout the city, and he moved down. And there was a public outcry. The question for me was whether public outcry can be a ground. And I referred to several judgments of the Supreme Court, and I said that public outcry can also be one of the grounds for aggravating, and I confirmed. Supreme Court reduced his sentence to life imprisonment because they said that obviously he was insane, though I had given my reasons. So mitigating circumstances are circumstances where looking at the age of the accused, looking at the background, and whether this is a first offense and under what circumstances this has been committed are all mitigating circumstances. And we have to balance the mitigating circumstances and the aggravating circumstances and come to a conclusion as to whether releasing him, uh, whether sentencing him to life would be helpful to the society, whether his continued life would be a threat to the society or not. So various angles have to be considered to decide, come to that conclusion.
Yes, sir. Also, this next, I'll take this as the last question. This is not directly related to our subject, but by and large, this is indirectly related to our subject. Therefore, I'm taking this question. The question is
Yes.
from one Mr. Harshavardhan, Advocate Harshavardhan. His question is, what is the opinion of Honorable Kanade sir on the issue of encounters that have been taken place, especially on the background of the encounter which has taken place at Hyderabad, where the accused in a rape case were shot at by the police. What is
Yeah,
the opinion?
personally, I am of the view that the police have no right to take law into their own hands. And if this practice is encouraged, in Marathi there is a saying, "Matari मेल्याचं दुःख नाही पण काळ सुखावतो." तसं, if this practice is allowed, the police on whom several restrictions have been imposed by the law will abuse the process of law and will resort to these. Though, of course, there is a other side of the coin, and that is because of the delay in administration of justice. So take the case of Nirbhaya. Almost 7 years passed and several cases were filed in various courts. Even on the last day, till about 2:30, the case was going on in the Supreme Court. So in such cases, the police become emboldened to do this, and they kill. They resort to encounter method. But personally, I believe that for ordinary citizens, protection of ordinary citizens, unless there is a real danger to the police because of firing by the accused, this should not be resorted.
Yes,
This
sir.
is my humble view.
Yes, sir. Yes. Sir, I thank you very much for giving us your valuable time. The most important thing is this, sir, that most of the lawyers from Taluka courts, they always, this is what I said yesterday also, because yesterday Ganu sir was here. The most of the lawyers practicing in Taluka court, they normally read the judgments of the High Court and they read
Right.
by whom the judgment is passed. So for these lawyers who are practicing in Taluka court and district court, Justice Kanade, Justice Ganu will always be in their imagination reading the case laws cited in different journals. So when you personally come and interact with lawyers from Taluka and district court, it's a very great experience for them. And then they also develop this habit of or start thinking that they also should come to the High Court. So therefore, sir,
Right.
it was very important for all of us that you personally give us a lecture or discuss subjects with us. I thank you very much on behalf of all the lawyers from Ratnagiri, Sindhudurg, Kolhapur, and even from Goa. And there today, some have come from Bombay also. So I thank you on behalf of all of them. Thank you very much, sir.
My pleasure and my privilege to talk to all the juniors and senior lawyers. Thank you. Thank you.
Thank you, sir. Thank you.